Although most memories fade over the years, certain events are so punctuated by overwhelming circumstances and emotion that no amount of time can erase their mark. Tragically, for many young citizens of the Commonwealth of Pennsylvania, the day they were adjudicated delinquent by former judge and now convicted felon Mark A. Ciavarella is such an event. Last fall, this court received testimony from over 300 witnesses who testified for the very first time about their experiences between January of 2003 and May of 2008 in Luzerne County Juvenile Court. Their collective testimony paints the portrait of justice derailed by a presiding judge who ruled with breathtaking arrogance and an unfathomable disregard of due process. Ciavarella, along with his co-defendant, former judge and fellow convicted felon Michael T. Conahan, orchestrated the shutdown of Luzerne County juvenile facilities in 2002 to make way for new detention centers. Unbeknownst to the public, however, both Ciavarella and Conahan received massive payouts for their assistance in the construction and eventual filling of the new detention centers. After these misdeeds came to light, plaintiffs initiated suit against various individuals and entities responsible for this scheme. Plaintiffs entered into a series of settlements with all culpable defendants except Ciavarella and Conahan. Our colleague, the late Judge A. Richard Caputo, previously entered judgment against Ciavarella and Conahan, and, consequently, the only matter pending before the court now is the issue of damages. Having heard plaintiffs' testimony and carefully considered the applicable law, we will award plaintiffs both compensatory and punitive damages. Plaintiffs filed suit in 2009 against numerous defendants, including Ciavarella and Conahan. The operative complaints allege constitutional violations pursuant to 42 U.S.C. Section 1983 for violations of the Racketeer Influenced and Corrupt Organizations Act, RICO, civil conspiracy, and false imprisonment. The court determined Ciavarella and Conahan were both liable under Section 1983 for violating plaintiffs' right to an impartial tribunal, as well as conspiracy to violate that right. Judge Caputo deferred his determination on damages for both defendants. In June of 2020, plaintiffs moved for a hearing to assess damages against Ciavarella and Conahan. After several days due to the ongoing pandemic, we received testimony in September and October of 2021 to determine plaintiffs' damages resulting from their now vacated juvenile adjudications by Ciavarella between January of 2003 and May of 2008 in Luzerne County. In separate correspondence filed to the docket, Ciavarella and Conahan waived their right to participate at trial. We now set forth our decision on damages pursuant to Federal Rules of Civil Procedure. In late 1999, Ciavarella approached Conahan and suggested that they bring together a team that had the financial ability to build a new juvenile detention facility, including with co-defendants Robert Powell and Robert Miracle. Powell formed the PA Child Care Company to construct such a facility. In 2012, during his term as president judge, Conahan orchestrated a placement guarantee agreement whereby the Luzerne County Court of Common Pleas would be required to pay rent to PA Child Care, or PAC. Ciavarella was also aware of the placement guarantee agreement, and he and Conahan stopped sending juveniles to existing facilities in the area. Both judges appeared on television in December 2012 and publicly discussed the need to shut down current juvenile facilities, clearly aware that such shutdowns would directly benefit PAC. Conahan informed Powell that Ciavarella would need to be taken care of financially to ensure the success of the PAC facility. In January and July of 2003, Powell and Miracle wired over $400,000 to Ciavarella using third parties, Robert Mata and Beverage Marketing of PA, to conceal the payments. Powell and Miracle partnered again in 2004 to construct another juvenile detention center, Western PA Child Care, WPAC. After the WPAC facility was completed in July of 2005, Miracle paid Conahan and Ciavarella an additional $1 million. A February 2006 addition to PAC resulted in another $150,000 payment from Miracle to Conahan and Ciavarella. In total, Ciavarella received over $2.7 million and acknowledged that he concealed all of the payments because he knew it wouldn't look good if he was receiving payments from Powell while also sending juveniles to his facility. Ciavarella admitted that from 2003 to 2007, he never informed any of the juveniles who appeared before him that he was receiving money from PAC, WPAC, or Powell. In January of 2009, the United States Attorney for the Middle District of Pennsylvania filed a bill of information against Ciavarella and Conahan alleging 2 counts of fraud. In September 2009, a federal grand jury returned a 48-count indictment against Ciavarella and Conahan, alleging racketeering, fraud, money laundering, extortion, bribery, and federal tax violations relating to construction and operation of juvenile detention facilities owned by PAC and WPAC. Conahan entered a guilty plea in 2010, a jury convicted Ciavarella in 2011, and both men were sentenced to federal prison. As criminal proceedings began against the former judges, the Pennsylvania Supreme Court in February of 2009 appointed a special master to review all Luzerne County Juvenile Court adjudications and dispositions affected by the recently revealed criminal allegations against the judges. In October of 2009, the Pennsylvania Supreme Court authorized the special master to vacate and dismiss with prejudice all cases in which Ciavarella entered adjudications of delinquency or consent decrees between 2003 and 2008. The court reasoned Ciavarella's admission that he received these payments and that he failed to disclose his financial interests arising from the development of the juvenile facilities thoroughly undermines the integrity of all juvenile proceedings before Ciavarella. Whether or not a juvenile was represented by counsel and whether or not a juvenile was committed to one of the facilities which secretly funneled money to Ciavarella and Conahan, this court cannot have any confidence that Ciavarella decided any Luzerne County juvenile case fairly and impartially while he labored under the specter of his self-interested dealings with the facilities. The Pennsylvania Supreme Court concluded that all juvenile adjudications and consent decrees entered by Ciavarella during this time period were tainted. Defendants' stunning abuse of power is underscored by statistics from the Juvenile Court Judges Commission, the JCJC. As summarized in the May 2010 report from the Interbranch Commission on Juvenile Justice, the statistical picture is striking. In 2003, Ciavarella ordered 330 juveniles from Luzerne County into placement. That was twice the state average. More significantly, in a county that represented less than 3% of Pennsylvania's population, this single judge was responsible for 22% of the juvenile placements throughout all of Pennsylvania. Over the next several years, there was a downward trend in juvenile placements across the state. Ciavarella followed this downward trend to some extent, but his placement rate still remained far higher than the norm. In 2007, he sent 219 youths into placement. In context, that number was 2.5 times the statewide average. Of 1,066 juveniles placed statewide in 2007, Ciavarella accounted for 20% of them, with placements from Luzerne County. Statistics provided by the JCJC demonstrate that waiver of counsel rates for Ciavarella's juvenile placements, that's children who waived their right to be represented by counsel, were 7 to 11 times higher than the statewide average during the relevant period. There's a graph. You can see the statewide numbers in gray at the bottom, 3.1, 8.2 at the most in 2001, 3.4 in 2007 after a downward trend. Meanwhile, Luzerne County's rates are 59, 58% with placement with waived attorney. Okay, so 50 to 60% of cases with a waived attorney resulted in placement, and it's more like 6 to 8 at worst, statewide. Against this startling factual and statistical backdrop, the court heard testimony from more than 300 individuals over the course of 2 months. A common theme emerged as witnesses described how these unlawful juvenile adjudications caused significant and enduring harm, touching every facet of their lives and their families' lives. In the Commonwealth of Pennsylvania, the Juvenile Act governs, among other things, proceedings in which a child is alleged to be delinquent. The stated purpose of the Juvenile Act includes supervision, care, and rehabilitation of children who have committed delinquent acts to allow them to become responsible and productive members of the community. Separating a child from his or her parents should be considered only when necessary and through the use of the least restrictive intervention necessary to balance public safety with the welfare of the child. Confinement, if any, should be for the minimum amount of time needed to carry out the statute's purpose. Thus, juvenile court judges should be guided by the concepts of balanced and restorative justice, and out-of-home placement should be the last resort. Observing that Ciavarella's methods failed to conform to these statutory directives is a gross understatement. Ciavarella had a zero-tolerance autocratic approach to juvenile justice. His objectives were to intimidate and then to punish. These draconian methods caused immeasurable injury. Indeed, his consistent use of in-state and out-of-state residential placements to address minor juvenile offenses and trivial probation violations devastated both the youths appearing before him and their families. It was the antithesis of balanced and restorative justice. Ciavarella's acerbic treatment of juveniles in court and his routine pronouncement of lengthy detentions wrought havoc on a generation of local children and adolescents and their families. At trial, we heard from 282 plaintiffs and 32 parents. The court finds the victims' testimony to be completely credible and credits their remembrances of specific events as well as their candid inability to remember others. Although their adjudications occurred well over a decade ago, many plaintiffs retained a vivid recollection of their various appearances before Ciavarella. They recounted his harsh and arbitrary nature, his disdain for due process, his extraordinary abruptness, and his cavalier and boorish behavior in the courtroom. The following trial testimony provides a flavor of what it was like to appear before former Judge Ciavarella. Setting: to a 14-year-old who appeared for an unpaid, underage drinking citation, accompanied by her mother. Ciavarella actually looked at me and told me because I liked to drink like the Bulldogs, I should get locked up like them too. He had 2 people detain me and started laughing at me when I went to go give my mom a hug, and he told me juvenile delinquents do not get to hug their parents goodbye. To a 15-year-old charged with breaking and entering into a residence which he considered his home, Ciavarella told me I don't need a lawyer. I was in front of him for 42 seconds, that was it, and I remember that number because it's my grandfather's favorite baseball player, Jackie Robinson. I hate that number because it's the amount of time it took him to decide that he was going to lock me up for 10 months. During a 16-year-old's appearance, awaiting a decision on his release after serving 3 months at Camp Adams, a detention center, Ciavarella said, "We'll stop the proceedings. I have to collect a bet." He donned a race cap. I forget which team it was, for a NASCAR team, and I'm not exactly sure the person who took the bet, but they were in the courtroom at the time. The examining court asks, "All right, and that person showed up and approached the bench and gave the judge money?" Witness: "He had placed it in his hand and the judge took his cap off and he stuck it inside the cap." To a 10-year-old in a schoolyard fight without serious injuries after she tried to explain that she was assaulted and was defending herself. Ciavarella told me there's no such thing as self-defense. Before a 16-year-old's hearing on his probation violation, Ciavarella had this one boy in front of me, and he asked the kid how many birds did he see in the tree outside, and the kid looked outside and was kind of laughing, and he said, "I think I see like 4 or 5 birds. Judge Mark Ciavarella said, "Okay, you get 5 months if you see 5 birds. Then I was up next, right after that, so I knew I was going away. During a 16-year-old's appearance as the result of an unpaid citation for smoking on school property. At the time, my parents had hired a paid lawyer, and so we went. I remember they took me from PA childcare to court, and when I got there, Ciavarella basically didn't let my lawyer speak at all. Like, pretty much like my lawyer didn't have any power whatsoever, so that was pretty much it. He didn't let me talk. He barely let my lawyer talk. He just sentenced me. Ciavarella said that I was a grown man and old enough to pay the fine myself, and they detained me. He said, 'Your mommy can't help you now.'" Recollection of a parent of a 14-year-old appearing on his first citation for drug use. "I do distinctly remember when we went in for the first sentencing, the substance abuse counselor began speaking, and Ciavarella just said to her, 'You sit down and shut up because he's going away. He's going away.'" To a 15-year-old charged with breaking into a house, but attempting to prove his innocence, Judge Ciavarella asked me what I pleaded, and I told him. I was like, "Not guilty," and I'm trying to explain why. He told me to shut up. I looked at him. I'm like, "Shut up?" I'm like, "All right, well, I want a lawyer then if that's the case." And he was like, "I don't have to give you nothing, but I can give you a sentence at Glen Mills until I say you're ready." Boom. And that was it. Literally, like, within 25 seconds, court was done. From a 16-year-old who spent 11 months in detention for driving without a license the wrong way down a one-way street. It seemed almost like he already had his mind was set. He didn't want to hear anything I had to say, and it was the very first time I was in trouble. The driving citation was literally all it entailed. He told me, "I want you to count the number of buttons on your blouse, and that's the number of months you're going away for." I was a little kid. I didn't understand, so I did. I looked down and I actually counted them out because I didn't know how many buttons I had, and there were 11. From a parent of a 17-year-old appearing for possession of marijuana, Ciavarella conducted like he wasn't a judge. He was like the king of the court. You couldn't say anything, you couldn't do anything, there was no explanation of what was going on or what was going to happen. To a 16-year-old in placement for 6 to 7 months as the result of a curfew violation, awaiting a decision on her possible release. Yes, one thing that I feel like I can't seem to forget is when I was in my last placement, I was there for 6 or 7 months, and I went to see Ciavarella to get released, and my grandmother was with me, and if she was alive today, this is something she used to bring up every now and then. He was wearing a red hat or red cap of a baseball team, and they were playing maybe that day, and he asked me what team I would choose, and I picked the wrong team. Because I picked the wrong team, I was going back to detention. And I did go back another 7 or 8 months, and I thought I was coming home. To a 15-year-old appearing as a result of an altercation with her brother, Ciavarella wanted to send me to Camp Adams, and I believe it was because he said I don't know how to behave at home, and I can remember the exact words that day. He let me go because he won a bet with a football game. He was feeling nice, he said. To a 13-year-old cited for graffiti using a marker on a school window. When I went to the pre-hearing meeting, they said that I was not going to get placed anywhere, that I was just going to get probation. And then I was in front of Ciavarella, and he said he was going to make an example out of me, and then he shipped me off to Camp Adams. Recollection of a plaintiff who was 16 years old during her adjudication. They decided that I was going to be sent away for giving the police officer the middle finger. Nothing else. I never had detention. I was never suspended from school. I was on the honor roll. I was in every club. I never did anything. I didn't even have a curfew because I didn't really even go places. I never drank in high school, I didn't smoke cigarettes, and when I was in front of Judge Ciavarella, he threw this huge book in my face and he says, "This is your record." And I'm thinking, my record of what? All the hundreds I've gotten since I was in kindergarten? These are the stories of just a few of the many, many victims of Ciavarella's abuse of power during his tenure as the presiding judge of juvenile court in Luzerne County. The court heard numerous accounts of senseless detentions. Of the 282 former juveniles who testified, 79 were under the age of 13. One individual testified that he was only 8 years old when he was first adjudicated by Ciavarella. After his initial appearance, this child was shipped to a slate of juvenile detention facilities for months at a time, including PAC, WPAC, Camp Adams Youth Camp, the Glen Mills School, and George Junior Republic. He estimated he spent around a decade in detention, bouncing from placement to placement. Like him, many youths were detained, adjudicated, and thereafter endured lengthy placements for minor infractions, including smoking cigarettes on school property, stealing a Hershey bar, writing graffiti on a school window, peeling paint off the side of the school swimming pool, opening a yo-yo in a convenience store, bringing a utility tool or pocket knife to school, jaywalking, truancy, shoplifting for food and necessities, making an obscene gesture or swearing at an adult, setting off a firecracker, taking a neighbor's bicycle for a joyride, pranking a school teacher by hiding her purse, and being a few minutes late for curfew. Witnesses specifically recalled the intense humiliation they experienced when realizing that they would be placed in juvenile detention and taken away from their families, particularly when they believed they would receive only a fine or probation. Yeah, that's called trauma. That's trauma. One plaintiff recalled that her mother attempted to speak with Ciavarella, saying, "Sir, she has never been in trouble before." And he responded, "You're a liar. She is a bad girl and now she is going to pay." Another testified that he brought a paycheck from his job at Wendy's to his hearing in an attempt to pay an outstanding fine. Ciavarella didn't want to hear anything. There was no say. I was just immediately cut off. The plaintiff recalled a court clerk or prosecutor trying to intervene on his behalf, but Ciavarella responded, "I don't care. He committed the crimes as a juvenile and he will be sentenced as a juvenile. You are hereby remanded to the detention center." Victims described the shock of being immediately handcuffed and shackled, and both children and parents became emotional while recalling that they were not allowed to say goodbye or hug their loved ones. Many plaintiffs noted their mere presence in the courtroom brought back terrible memories. As one stated, "Even though I am 31 and learned to move on from this corruption, having to relive it, this truly has brought back the worst memories and thoughts. All I can visualize is his disgusting smirk and smile as they took me away, the sounds of my mother crying, and I can hear the shackles clinking off the floor. Mark Ciavarella will forever be a monster who took my innocence away. Similarly, a parent recalled, I didn't even get to tell him that I loved him and that everything was going to be okay. It was devastating to my family. He was shackled and handcuffed like he was a murderer. He was only 12. Let me break in here for a moment. The case and the circumstances that we've gone over so far are certainly one level of extremely upsetting. We're about to go over the worst part of it. So if you don't want to hear about what happened to the children when they were in detention, you might want to skip ahead. I'll put chapter markers in the description below, and you should be able to click on them either in the description or on your timeline. Many victims spoke of being placed in facilities populated by individuals charged with far more serious offenses, including armed robbery, arson, aggravated assault, sexual offenses, and other violent felonies. One witness remarked on the stark contrast in charges between juveniles from Luzerne County and other areas of the state, noting, "The people that I was housed with at Camp Adams were there for serious offenses from surrounding counties, assaulting an officer, robbery, arson. And then there were people from Luzerne County that were in there for stealing a pack of M&Ms or getting into a tiff with their high school teacher." We also heard numerous accounts of individuals who learned how to be a criminal simply by being exposed to hardened juvenile offenders with whom they were placed, as one plaintiff recalled. "I went in as a kid when I was supposed to be learning to drive, and I came out more as a criminal. I learned how to become a criminal when I was supposed to be learning to go to prom, get my license. Those were the best years, supposed to be, of my life, and instead I'm learning how to sharpen a toothbrush." A number of plaintiffs suffered physical injuries while defending themselves against other youths. A plaintiff stated that the adults operating one facility explicitly permitted juvenile fighting, testifying, "The staff at St. Mike's would allow you 60 seconds. If you had an altercation with anybody, they'd let you go into a room and fight it out. They condoned that. They encouraged it." Other plaintiffs recalled physical beatings from the adults. As one noted, when the staff members broke up a fight, they flipped us, and it really wasn't so much of a restraining, more like a beatdown. According to witness testimony, threats of sexual assaults were alarmingly common in these facilities, and sexual assaults did in fact occur. One plaintiff stated, "I was told quite frequently that I was going to be assaulted in the shower. The CO's staff members were very brutal. Every day was a constant threat of some kind of violence." Another witness described his experience at Northwestern Academy fending off an attack from a peer by using the brush issued to detainees to polish their boots. One plaintiff testified that the abuse he suffered resulted in an STD. Another recalled his fear upon seeing kids come out of the showers and the back of their sweatpants filled with blood. Still another described being assaulted, choked unconscious, kicked, and punched by staff who wished to establish dominance over him at the facility. These juvenile detainees were also forced to fend for themselves in other ways. Several victims testified regarding the lack of adequate medical care in detention, if they received any at all. For example, witnesses specifically recalled that they did not receive routine medical attention for physical maladies, including an asthma attack, a dental abscess, an eye infection, a concussion, or a sprained ankle. A plaintiff who entered detention at Camp Adams 2 days after having a cast removed from his broken foot was forced to participate in physical activities despite presenting a note from his doctor. Instead of providing medical attention, staff worked him harder, and he fractured his foot in the same spot, which never healed again correctly. One plaintiff testified that he contracted tuberculosis while detained at PAC and required hospitalization. 2 female plaintiffs testified that they suffered from yeast infections and urinary tract infections because the detention facility used recycled undergarments and forced them to wear other people's clothes. Another testified that her untreated UTI worsened to the point that her detention was cut short. One parent recalled that her daughter was hospitalized in placement, stating, "In Danville, a guard broke her arm in 4 places. She had, from her shoulder all the way down, casted." Another plaintiff recalled that a guard at Camp Adams smashed his face repeatedly off the desk, sending him to the hospital. Many plaintiffs testified about the brutal emotional toll their detention exacted while they were away from their families. One testified that she tried to commit suicide while in detention by cutting her wrists, resulting in a hospitalization and 132 stitches and 19 staples. Another described how she was sent to a local hospital several times for suicidal thoughts and actions, yet her detention continued despite recommendations that she be sent home. She recalled that staff at the facility bullied her due to her mental health, stating, "They made my mother agree not to see me as punishment for being suicidal." Another testified, "I was always trying to ring the buzzer to try and make them let me go home. I was really young, I had panic attacks, I couldn't sleep, I just acted out, it was kind of a PTSD, I couldn't sleep, nightmares." These experiences underscore yet another grievous problem of Ciavarella's zero-tolerance, one-size-fits-all approach to juvenile offenders. The record before the court is effectively devoid of evidence that individual mental health circumstances were taken into consideration before placement was ordered. Extended residential placement was the default method of dealing with juveniles, evidencing any form of mental illness. Consequently, an inordinate number of former juveniles suffering from significant mental health issues were shipped off to detention facilities without consideration of placement alternatives, which would have put greater emphasis on mental health treatment and counseling. Plaintiffs' harm also extended to their education. In-detention schooling, to the extent where it occurred at all, was minimal. One plaintiff recalled that his only form of education was watching the 1990s animated series The Magic School Bus, and that he required special education classes after his detention ended. Another stated that his education was pretty much non-existent. They'd just throw us in a room and told us to read a book. Still another recalled doing nothing but word searches and crossword puzzles. One plaintiff described his experience during an 18-month detention. "I did receive schooling, but the only way I could describe it is I thought it was a joke. The schooling that I went through when I was there was remedial at best. It was just kind of somewhere for us to go and sit for 8 hours a day, I guess. I didn't actually feel like I received an education of any kind for that time." Plaintiffs also missed out on life events during detention, from weddings and funerals to vacations and religious holidays. Several testified that close family members died and they were not allowed out to attend the funerals. One plaintiff's father died from cancer. Although he was able to attend the funeral, he had to do so in handcuffs and shackles. Another plaintiff summarized the trauma of attending his grandmother's funeral in handcuffs and shackles. "And can you tell me or describe for me the emotional and physical injury that you suffered as a result of this placement for driving the wrong way down a one-way street?" Witness: "Absolutely. My grandmother, who pretty much raised me, passed away while I was in there, and I had to attend her funeral in handcuffs and shackles, which was very embarrassing for my whole family to see me, and it was just really hard having to go back there that night knowing that she had passed away. Being a child at that point, I would say that's a little like the starting point of my life, and just everything went downhill. I learned more about, the dark side of life, drugs and stuff like that, in there, prior to never really knowing about that stuff." Upon their return to school and the larger community, countless plaintiffs described a stain on their reputation, even if they had never previously been in trouble with authorities. One plaintiff recalled his shame and embarrassment in school because he had to have a security guard bring him to each class. Plaintiffs spoke about being ostracized from friend groups, and noted school officials labeled them as bad kids or criminals. One plaintiff recalled, "I was arrested at my high school, and after the whole experience, people witnessing that, I had anxiety being around everybody at school. I was labeled." A parent described how her son's friends isolated him, stating he was not allowed to go to their homes after his release from detention. Another plaintiff summarized the social stigma he experienced after detention. "My friends' parents no longer wanted them to hang out with me. I was from a small town, and pretty much the whole community knew of me, and from that point on, I was a criminal. Everyone looked at me that way. All my friends changed. I started hanging out with a different crowd because that was the only crowd that would hang out with me. I no longer played sports. Coaches didn't want a criminal on their team." Plaintiffs' educational harm also continued after detention. Several plaintiffs informed the court that they were expelled from their previous schools due to their juvenile records. Many were forced to enroll in alternative schooling. Others began failing classes, repeating grades, or dropping out altogether. One witness summarized her lack of education in detention by stating, "When I finally came home, I was in 11th grade, and I didn't know how to be in school." Many of the defendant's victims have been diagnosed with post-traumatic stress disorder, depression, anxiety. Many also suffer from recurrent thoughts of suicide. One plaintiff stated, "Even just coming here today, when I heard this case was reopening, I had nightmares about it almost twice a week. I never tell anybody about this period of my lifetime." Another testified via video that she chose to appear virtually because I am terrified of the justice system. I'm doing this video testimony because I am terrified of the courtroom, and even this is making me nervous. Tragically, but not unexpectedly, many plaintiffs spoke of self-medicating with illegal drugs, leading to the vicious cycle of drug addiction. One plaintiff testified that he suffered a serious back injury during his detention in Camp Adams and was prescribed opioids, to which he later became addicted. Several of the juvenile victims who were alive when this litigation commenced have since died from overdoses or suicide. Their parents testified, and one poignantly observed, "He couldn't get over it. Every place he went, even though all of this was supposed to disappear, nope, you were involved in all those crimes, you're no good." That's all he ever heard. He couldn't take it no more. He left behind a 10-month-old child. I'd give up my life immediately if he could come back and be with his son. Also, you could have some money. The presence of continuing psychological harm was palpable. Numerous victims broke down while testifying, tears flowing and emotions bursting over the loss of their self-esteem and the destruction of their childhood. Witnesses painfully described the permanent scars caused by Ciavarella and Conahan. As I wrote my opening statement, I get flashbacks of trauma coming to me, and thoughts and emotions I wanted to bury, of self-doubt and drug use and just heartache. The feeling of being cheated out of these things that I planned to work for my whole life or career at that point were robbed of me because I was seen as a payday for judges regardless of what the charges were. Judges are there to protect our rights, says another, and I don't think that anything was ever done for us. I know so many people that were in my shoes, and there's a courtroom full of them. No amount of money can replace a childhood. Another, that's why being here today is so important to me because, I don't want anybody to ever go through that. I can't even talk about it without crying. So obviously, it has an effect on me. There was a lot of struggle along the way. I'm thankful that you guys let us come up here and say this stuff because, for nothing else, it feels good for people to listen to you. Ciavarella just ruined my life, says another. I never got to experience none of my childhood. Nothing. He just didn't let me get to my future. Another, I really wish Ciavarella would have been here today, just to look him in the eye as all these parents and victims. And it's terrible. You can't put a price on life, It's sad. Yet another, I could sit here the whole day and go over how this affected my life, but it was just a cascading effect from when it all started. You tucked me under the rug and sent me home and didn't give me education or didn't give me anything. So what you set me up for was failure. It was literally failure. I was a number and I was just put into the system. That's how I feel about it. He was the one who introduced me to that system, and it took me a long time to get out of it. A long time. Yet another. My detention caused very deep and pivotal ripple effects in my life. It pretty much put negative mindsets and terrible coping mechanisms for me to come up with to have a transition from a young kid to a young adult. I developed an institutionalized mindset. Another. No amount of money can fix the once happy child forever lost years ago to those selfish men that I assure you will never return. A $17 million payout from a real estate tycoon and 17 and 20-year sentences in federal prison isn't long enough to account for all those years stolen from me as a child by cowards who chose personal financial gain over the most detrimental learning years of a young adult's life, who chose personal financial gain with no regard to the physical or mental well-being of those same children or the negative or social impact it would have regarding developmental delays or lifelong trauma for the children they were supposed to help. Another. I will close with one final thought. The Luzerne County court system failed us. They, Ciavarella and Conahan, had abused their power and, in my opinion, should never see daylight again. The scars of this scandal will continue to live with all of us. As a survivor, I can assure you that the impact of this man's greed will never be over or forgotten. Another. It still bothers me today because I honestly believe I feel I was just sold out for no reason. Like everybody just stood in line to be sold. But I didn't know we were to be sold. Just one after another, we were incarcerated. Another. The one thing I did want to say is, if I had an amount, of money that could be given to me, But if I could trade that for my time, 15 months roughly, and if I could be a teenager and not ever have had this happen, I would want my time to go back and just be able to finish high school and have a senior year and, just not go through this. So time is more valuable to me. Last, well, I'll tell you what, Ciavarella and all those judges, they invented a new kind of child abuse. Victims spoke of widespread trust issues as a result of their adjudications, and in particular, losing respect for the legal system and its authority figures. A plaintiff testified about the lasting effect his detention had on interactions with law enforcement. Last year, I was at a regular traffic stop. I was trying to explain to the police officer that with him standing over me and everything was the reason I was shaking and couldn't really contain myself. I ended up having to show my mental health records in court to explain why my behavior was so erratic. One parent noted that her son now always carries his rights in his pocket because he realized that if he didn't know what his rights were, then they would be taken away. Another stated, where do you go? What do you do? Who do you go to? What do you do? I certainly don't have these answers. I said these are the people we're supposed to trust. This is what we teach our children. If there's ever an issue, it's the police, it's the courts. They are the folks we're supposed to protect and make sure that's what's correct and what's right is done. And they completely failed everybody in this whole situation. As is often the case in such circumstances, says the court, painful lessons have been learned and reforms have been undertaken. Because of this scandal, the Commonwealth passed Act 32 in 2009 to temporarily establish the Inter-Branch Commission on Juvenile Justice, the ICJJ. The ICJJ's May 2010 report recommended, among other things, updates to the Pennsylvania Code of Judicial Conduct, guaranteed access to defense counsel in juvenile court, reduction in the use of shackles in juvenile courtrooms, and procedural requirements to ensure any juvenile court judge's decision to remove a juvenile from the home is based on the purpose and goals of the Juvenile Act. These and other improvements have since been enacted. Such reforms may be cold comfort to plaintiffs, but it is their legacy to have prompted better procedural protections for future generations of juveniles charged with criminal offenses. This court previously granted summary judgment in favor of plaintiffs on their claims against defendants Ciavarella and Conahan on all issues of liability for which defendants were not protected by immunity. This determination of liability included, among other things, defendants' violations of their rights to an impartial tribunal as well as conspiracy to violate that right, as well as the 5th, 6th, 14th Amendment. Plaintiffs seek both compensatory and punitive damages. We will address these types of damages seriatim, or one after the other. Compensatory damages are intended to make plaintiffs whole. In Section 1983 cases, compensatory damages are governed by the general tort law compensation theory. Stated differently, damages may be awarded for actions that violate constitutional rights and cause compensable injury. Compensable harms may include monetary injury and out-of-pocket loss, as well as non-economic losses such as reputational injury, humiliation, and mental anguish and suffering. A plaintiff's non-economic damages cannot be precisely calculated. Courts may consider awards in comparator or comparable cases, those involving similar conduct and injuries, as a helpful guide in assessing damages. This court has adjudged both Ciavarella and Conahan liable for violations of and conspiracy to violate plaintiff's right to an impartial tribunal. Yet the court's independent review of damages case law reveals a dearth of guidance for this particular type of constitutional violation. As noted, the Pennsylvania Supreme Court vacated all of Ciavarella's adjudications of delinquency for the relevant time period. The decision to vacate scores of juvenile adjudications because of fundamental unfairness in the proceedings bears striking resemblance to suits involving wrongful imprisonment. Hence, we will examine wrongful imprisonment case law for guidance in determining an appropriate compensatory damages figure. 2 district courts have concluded that $1 million per year of wrongful imprisonment in an adult prison may reasonably compensate a plaintiff's injuries. We have also considered the following cases: Connick v. Thompson, a jury award of $14 million for 18 years of wrongful incarceration, including 14 years on death row. Singletary v. D.C., a $2.3 million award for 10 years of confinement on wrongful conviction of parole violation. Parrish v. the City of Elkhart, An average jury award for wrongful conviction is nearly $950,000 per year, with a median of nearly $790,000. This goes on. Skipping ahead. The Newton case is particularly instructive because the district court there surveyed many cases, including the ones listed above, awarding damages for wrongful incarceration. In Newton, the court sought to establish an upper boundary for wrongful incarceration awards where the plaintiff had 2 convictions, only one of which was overturned. After analyzing comparable recoveries, the court granted the defendant's motion for remitter, concluding that $1 million per year is the upper boundary for similar cases. Importantly, the court factually distinguished various awards based on a number of factors, including the following. 1, the nature and length of the sentence imposed, death row for murder, or a term of years for lesser crimes. 2, whether the individual was serving time in a juvenile facility or adult prison. 3, whether the individual was previously incarcerated. And 4, whether the wrongful conviction was caused by negligent acts or omissions or intentional misconduct. Applying these factors to this case, we observe that plaintiffs were sentenced to placements of limited duration in juvenile facilities. Many witnesses testified about the harsh conditions and the violence and abuse permeating these facilities. We have considered this important testimony. We have also considered the fact that plaintiffs' unlawful detentions occurred at a critical time in their development when they were susceptible to negative influences, yet lacking the benefit of immediate family support. The abrupt and difficult adjustments that these youths faced cannot be overstated. Although their placements were unquestionably harrowing, we are also compelled to observe that plaintiffs did not suffer the conditions of an adult prison or the security restrictions of inmates on death row or serving life sentences. The 3rd and 4th Newton factors weigh in favor of plaintiffs. Although several plaintiffs were adjudicated delinquent before their first experience with Ciavarella, the vast majority were not, and none were previously incarcerated in adult facilities. Finally, it is abundantly clear that the wrongful placement decisions were the result of egregious misconduct, not mere negligence or inadvertence. We make one final observation. Plaintiffs' adjudications were vacated, but, unlike the wrongful convictions surveyed in Newton, none were overturned based on the plaintiff's actual innocence. The court recognizes that this distinction is immaterial to many plaintiffs who should not have been adjudicated delinquent in the first place. We are also cognizant that, generally speaking, plaintiffs were never provided the opportunity to prove their innocence or to present mitigating evidence. We note that there is a difference between a finding of actual innocence and having an adjudication vacated due to the taint of judicial misconduct. Having considered comparable awards and the distinguishing factors set forth in Newton, the court concludes that plaintiffs are entitled to compensatory damages at an initial base rate of $1,000 per day of wrongful detention. The court has prepared a damages appendix which sets forth the number of days that each plaintiff was wrongfully detained. For certain individuals who could not recall the precise length of their placement, the court has estimated the number of days in detention based upon their testimony, record evidence, and the submissions of plaintiffs' counsel. Thereafter, the court calculated plaintiffs' initial aggregate awards by multiplying the number of days in detention by the base rate of $1,000. Having determined the initial aggregate award, the court adjusted these awards in a final step to meaningfully reflect the unique circumstances and experience of each plaintiff. We emphasize that we have carefully considered all record evidence, including multiple reviews of testimony received at trial, and we have varied the initial aggregate award to reflect our necessarily subjective view of the appropriate amount of compensatory damages for each participating plaintiff. Punitive damages. Punitive damages may be warranted in a Section 1983 civil rights suit where a constitutional violation has occurred even in the absence of compensatory or nominal damages. For example, punitive damages may be awarded if the defendants were motivated by evil motive or intent, or acted with reckless or callous indifference to the federally protected rights of others. Punitive damages serve deterrence and retribution functions, and are reserved for circumstances involving something more than a bare violation of constitutional rights. Such awards may be particularly appropriate as a means of vindicating the public interest in preventing violations of civil rights by state officials. Punitive damage awards are not, however, without limits. The United States Supreme Court has developed a set of guideposts to prevent grossly excessive punitive damage awards, as such awards violate due process. In fashioning a punitive damage award, a court may consider 1. The degree of reprehensibility of the defendant's actions, 2. The disparity between the harm or potential harm suffered by the plaintiff and its punitive damages award, and 3. The difference between the punitive damages award and the civil penalties authorized or imposed in comparable cases. The reprehensibility analysis is the most important indicium of the reasonableness of the punitive damages award. Under this guidepost, the court examines several factors such as whether the harm caused was physical as opposed to economic, the tortious conduct evinced an indifference to or reckless disregard of the health or safety of others, the target of the conduct had financial vulnerability, the conduct involved repeated actions or was an isolated incident, and the harm was the result of intentional malice, trickery, or deceit, or mere accident. The disparity analysis does not require a bright line ratio, but few awards that exceed a single-digit ratio between punitive and compensatory damages to a significant degree will satisfy due process. So they're saying no more than about a 2 or 3 times multiplier, I think. In cases with a substantial compensatory damages award, the Supreme Court has postulated that a smaller ratio, perhaps only equal to compensatory damages, may satisfy the strictures of due process. This is the 2008 case of Exxon Shipping v. Baker adopting a 1-to-1 ratio as the upper limit for such awards in federal maritime cases. A more appropriate case for punitive damages is difficult to conjure. The facts presented coincide with all the aggravating factors in the case law reprehensibility analysis. As set forth at length herein, children and adolescents suffered unspeakable physical and emotional trauma at the hands of 2 judicial officers who swore by solemn oath to uphold the law. Instead, Ciavarella and Conahan abandoned their oath and breached the public trust. They conspired to close existing detention facilities and construct new ones in exchange for millions of dollars and the steady placement of Luzerne County youths. Their cruel and despicable actions victimized a vulnerable population of young people, many of whom were suffering from emotional issues and mental health concerns. These wrongful acts warrant punitive damages in order to achieve the objectives of deterrence and retribution. Furthermore, the circumstances of this case far exceed a bare violation of plaintiff's constitutional rights to an impartial tribunal. And due to Ciavarella and Conahan's status as former state officials, we conclude punitive damages assist in vindicating the public interest in preventing violation of civil rights. In arriving at an appropriate dollar amount, we are mindful of the remaining guideposts for reasonableness set forth in case law, namely the disparity of the harm suffered by plaintiff and the punitive damage award, and the difference between the punitive damages award and the civil penalties authorized or imposed in comparable cases. In light of the Supreme Court's specific observations in State Farm and Exxon, that substantial compensatory awards should result in a smaller ratio between punitive and compensatory damages, we conclude that a ratio slightly less than 1-to-1 satisfies the strictures of due process in the instant case. Accordingly, we will award punitive damages in the amount of $100 million. Conclusions. Plaintiffs are the tragic human casualties of a scandal of epic proportions. The law is powerless to restore to plaintiffs the weeks, months, and years lost because of the actions of the defendants. But we hope that by listening to their experiences and acknowledging the depth of the damage done to their lives, we can provide them with a measure of closure and, with this memorandum opinion, ensure that their stories are never forgotten. Based on the court's individualized review of the record evidence, we will award plaintiffs compensatory damages as set forth in the damages appendix. We will further award $100 million in punitive damages against defendants Ciavarella and Conahan. And that is Judge Christopher Connor, United States District Judge for the Middle District of Pennsylvania, August 16th, 2022. And here is that damages appendix. I have placed a gray box over the names of the individuals. You can see here what the final compensatory damage awards are in this 23-page report. Many of these people spent hundreds of days in detention. Here's one that's listed as the estate. Another one. Here's four that are listed as the estate. Yeah. Some of these are listed as the estate. And these are people who were children not that very long ago. so they shouldn't be dead. So yeah, I don't have a lot to say. It's horrible, and it speaks for itself. I have some personal experience with this kind of abuse, and I wouldn't wish it on anybody. Mine was light. Some of these people got really heavy stuff. And it affects you. It affects you for the rest of your life. It affects relationships. It affects jobs. It affects education. It affects opportunities. So you can expect that, generally speaking, people who have suffered trauma like this will have struggles, extra struggles throughout their lives. So it's worth telling their story and trying to get any kind of justice for them. Justice will never be done for these people. Fairness will never be accomplished. You couldn't give them enough money because that's not what they want. Money certainly lubricates things, life and society, and can buy you some artificial happy times and can maybe facilitate the naturally happy times that help. But you can't give people naturally happy times, and you can't give them back the time that they lost. And let's not forget, they were also victims of the system, not just the system that allowed and enabled Ciavarella and Conahan, but you heard about that abuse in juvenile detention. These are caretakers of our children. It would be like if you sent your child to daycare and they got beat up instead. They got beat up by the staff. Yeah. Why do we put up with that for juvenile offenders, or really any offenders? We wouldn't put up with it for putting your kids in daycare. You certainly don't put up with it from a nanny or a babysitter. Why do you put up with it when you put your kids into juvenile detention? So those are also crimes, and I hope that the victims were able to receive compensation, and I hope that the perpetrators of those crimes went to jail as well, but I doubt it. We all know that that's not how that works. Anyway, I'll let that be the end of that show. Let me know what you think in the comments below.